Have you ever watched a courtroom drama and heard someone mention circumstantial evidence, perhaps in a way that makes it sound less important than other types of proof? It is a common term, but its true role and power in our legal system are often misunderstood. Circumstantial evidence refers to facts that do not directly prove a main point at issue, but instead establish other facts from which a reasonable inference can be drawn about the main point. For example, finding a suspect's fingerprints on a weapon does not directly show them using it, but it certainly suggests their presence and involvement. And like direct evidence, which immediately proves a fact, circumstantial evidence requires a judge or jury to connect the dots and make a logical conclusion. The power of circumstantial evidence lies in its ability to build a strong and compelling case by painting a complete picture through various indirect facts. Think of it like assembling a puzzle. Each piece, though not directly showing the final image, contributes to its clarity when combined. The law considers circumstantial evidence to be just as valid and often as powerful as direct evidence. In many cases, it can even be more reliable than direct evidence, such as a mistaken eyewitness identification, because multiple pieces of evidence corroborate each other. For you, understanding this means recognizing that a legal case is rarely simple, and justice often relies on more than just a single smoking gun. If you ever find yourself involved in a legal matter, remember that every detail, however small or indirect, could play a crucial role in building or defending a case. Lawyers carefully gather these individual pieces of circumstantial evidence, presenting them together to form a clear and persuasive narrative that leads to the desired conclusion. Courts frequently use circumstantial evidence to establish elements like motive, opportunity, and intent. For instance, evidence showing a person made threats against another, had access to the location where an incident occurred, and stood to gain from the outcome, all serve as circumstantial evidence. When these facts are presented convincingly, they can meet the high legal standard of proof required, whether that is beyond a reasonable doubt in criminal cases or a preponderance of the evidence in civil disputes. Ultimately, circumstantial evidence is not a weaker form of proof, but rather a sophisticated and widely accepted method courts use to determine the truth. It encourages a thorough and holistic examination of all available facts, ensuring that decisions are based on a logical and well-supported understanding of what likely occurred. By understanding how this type of evidence works, you gain a clearer insight into the meticulous process of uncovering justice in our legal system.